Hi, I'm Michael Hughes, and this is Contract Mastery. Today, let's talk about paragraph 4 of the 1-to-4 family residential contract. It pertains to leases that are applicable to the property, and not just residential leases. It deals with all different kinds. So there's residential leases, there's fixture leases, which we'll talk about here in just a minute, and there's also natural resource leases. So the contract says, except as disclosed in this contract, the seller is not aware of any leases affecting the property. So that's our baseline. Unless we say otherwise, there are no leases impacting this property. After the effective date, the seller may not, without the buyer's written consent, create a new lease, cannot amend any existing lease, and cannot convey any interest in the property. And then they ask us to check all of the boxes that may apply. So the first thing we're going to talk about are residential leases. So a residential lease means any lease of any kind to any person. It can include a written or unwritten lease. It also includes the situation where you have a relative who's just, quote, quote, using the property. It also includes situations where you have a tenant at sufferance, or in other words, a trespasser. Any lease where there is a person using the property as their residence and they don't own the property, that is considered a lease for purposes of paragraph 4. So if the seller is not occupying the property, and if there is any person other than the seller who is occupying the property, then we're going to require a residential lease addendum for our 1-to-4 family contract. So in 4A, it says the property is subject to one or more residential leases, and the addendum regarding residential leases is attached to this contract. We're not going to go into detail about the residential lease addendum today. We'll have a separate class specifically on that document. But you need to be aware if there is any kind of lease situation going on, whether it's a voluntary or involuntary lease from the seller's perspective, we are going to have to attach this additional document. And we're going to have to do something about the residential leases before the closing date. The second category talked about in the contract are a fixture lease. So previously, we talked a little bit about fixtures and improvements in the definition of property in paragraph 2. And we said that a fixture is an item that is permanently affixed or it becomes attached to the real property in such a way that it becomes part of the realty and conveys along with the sale of the property. So that's review. But now we're going to add in a little wrinkle. What if there was a fixture that the seller did not own? Somebody else owns it. What do we do with those? Certain big ticket items are permanently attached to the real property, but instead of the seller owning them outright, the seller just leases them. And some common examples are solar panels, propane tanks, water softener systems, home alarm systems, the panel that's on the wall. Oftentimes, those are not owned by the homeowner. They're leased from the alarm company. When these items exist, when there are fixture leases on the property, they're going to be subject to a lease agreement between the seller and whoever provided the equipment. Let's say the solar panel company for this example, right? So there's a lease between the seller and the solar panel company. The seller cannot agree to sell that equipment Because she doesn't own it. The solar panel company owns the solar panels, right? The disposition of the leased fixtures and of the lease that governs those leased fixtures has to be resolved before the closing date. Because as we'll see a little bit later on, the seller has to turn over the property free and clear of any sort of debt or encumbrance, unless the buyer agrees to assume or to take on the debt or the encumbrance or the fixture lease. And so if we have any of those types of things going on in our transaction, we do have to fill out and complete and attach the addendum regarding fixture leases to the contract. We're going to talk about that document in detail in a different class session. But for now, you need to know this is where it comes into play in the 1-to-4 contract if there are items that are permanently attached to the property, but the seller does not own them outright. Let's talk a little bit about natural resource leases. It's a gusher. It's a gusher. So natural resource lease. A natural resource lease means an existing oil and gas lease or a mineral lease or a wind or a water lease or any sort of other natural resource lease affecting the property to which the seller is a party. So anytime an oil company, let's say, goes onto a property and they want to drill for oil, well, somebody else usually owns that land. And so the oil company can't just go onto the land and start drilling. They have to get permission. And the way that that is done in oil and gas law is through an instrument called a natural resource lease. They are leasing the rights to go in and drill for and extract the natural resources. So if there are any of these sorts of documents that are applicable to this property, we have to provide a copy of this natural resource lease to the buyer. So the first thing that we want to know in the contract is whether or not, as of the effective date, the buyer has received a copy of the natural resource leases. So we have a couple of check boxes here that says, 1, yes, the seller has delivered to the buyer a copy of all the natural resource leases. Or option 2, the seller has not delivered to the buyer a copy of all the natural resource leases. And in that case, the seller will provide to the buyer a copy of all the natural resource leases within 3 days after the effective date. The buyer then has an agreed number of days in which the buyer can terminate the contract and get back the earnest money. So if there are natural resource leases and if the seller does not provide them before the contract is executed, then the seller has to provide a copy to the seller within 3 days after the effective date. The buyer then gets an agreed number of days to look over the natural resource leases and decide whether or not she wants to continue on with the transaction. If she does, great. If she does not, then within that agreed number of days, the buyer has the right to terminate the contract and receive back the earnest money. A couple of things to remember here. For a residential lease, if there is any person other than the seller who is occupying the property and the seller is not occupying the property, then the addendum concerning residential leases is probably going to be required in your transaction. That should set off a red flag for you. For fixture leases, if there is anything permanently attached to the property, but it is not owned by the seller, and instead the seller is leasing it from some outside party, then you're going to have to include the addendum concerning fixture leases.